This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
The topic today is disinheriting spouses, and we're going to hear from Wes Mussio, the managing partner at Mussio Goodman Law Firm.
Thank you.
Can a spouse be disinherited?
Well, the long answer is no, they can't, except for very special circumstances. Basically, what the courts look at is they have a test which is called a legal and moral obligation. So a spouse that passes away has a moral and legal obligation to provide for their spouse at the time of death. So with that type of principle involved and looking at what we call its testamentary autonomy, which means the will maker gets to choose who gets their assets, well, the legal and moral obligation takes priority over the testamentary autonomy.
Doesn't the will writer get to decide her or his own will or affairs?
Well, British Columbia is one of the only jurisdictions in Canada, if not North America, where the answer is no, they don't, because the Supreme Court of Canada has looked at balancing act, and so there's a lot of will makers that are being vindictive or not fair to their family members, and the courts have said no, that can't happen. What we have to do is look at the legal and moral obligation, and when you look at the legal and moral obligation based on an objective test, which means what would people in the industry and in society believe, and they believe that disinheriting your spouse would be not right, and so the courts have basically said no, you can't disinherit your spouse, you have to provide for them in the time of your death.
When is the spouse not able to dispute a will?
Well, the only time you probably be not able to dispute the will is if the testator, the will maker, had set up a plan for them. So let me give you an example. If the deceased had a house and puts the spouse as a joint tenant, then the spouse would get that house upon death. And similarly, if he had a bunch of RSPs and investment portfolio and so forth, and the spouse has got the right of survivorship on those or the named beneficiary, they would automatically go to her upon death. So in a situation where a vast majority of the assets go to the spouse outside of the will, not in probate, then yes, you can disinherit your spouse and you can provide to your children or whatnot. So there are some situations, but they are relatively rare because the legal obligation is so strong. And what the legal obligation is simply put, if you were to die, say January 1, the court assumes that you got divorced January 1 from your spouse, and what would your spouse get in family law would be the answer to the minimum that the testator has to provide to the spouse when they die.
What is the expected requirement to provide for the spouse?
Well, that's where you get into the moral and legal obligation, like I said, and so the legal obligation is assuming a divorce at the time of death, and whatever the spouse would have to provide under the Family Law Act. That would be what's called a legal obligation, and so that includes splitting assets. We've all heard like the 50-50, whatever is being built up during the relationship, that this one spouse should get at least 50%. And then the other thing is spousal support. So if you have a situation where the fellow that passed away is the breadwinner, then the other individual should get spousal support as well. But there's also what's called a moral obligation, and that again is looked at as if you're in a situation where you're asking the average person in Canada, well, the answer is, your spouse deserves something, so that's heightened the amount that the spouse should get under the will. And so that takes complete priority over the testamentary autonomy, which is again the will maker's decision making on where his or her assets go.
Do you have any examples of where disinheriting spouses would be relevant to?
Yeah, it brings up an interesting story of this very rich family in Shaughnessy in Vancouver, where the husband had set up this multitude of various assets that he had were going to the spouse outside of the will, so that she would basically get 50% of the estate. But the court ultimately ruled that still wasn't enough, because if one looked at what she got, she should get more than the 50%. And so that just solidifies my comment that any spouse that is disinherited under a will, the vast majority, if not 99% of the cases, they could definitely go to court and have the will varied so that they get additional funds, even if they received quite a bit outside of the will. And if you have any further questions on this topic or others, feel free to reach out to me at my email, mussio@mussiogoodman.com, or give me a call at 604-336-8002.